Assalamualaikum and good morning everyone. It's an honor to be presenting for our Tort Law's class on an amazing comparative analysis research on the challenges in implementing duty of care in healthcare. Let me introduce our group members. We have Kansa binti Kamarum Zaman, Adrana Khalisa, Wu Sin Yi, and also myself, Aisha Nurjana.
We use doctrinal legal research analyzing Malaysian cases, statutes, and medical guidelines on duty of care, supported by textbook and journals. We also run a Malaysia-Switzerland comparison on institutional responsibility, systemic negligence, and type risk. Finally, we critically evaluate whether Malaysian law fits real pressures, and we also suggest improvements.
The literature shows that duty of care is central to medical negligence but is no longer shaped only by individual fault. Recent studies highlight how legal pressure, resource shortages, and technology increasingly affect healthcare practice and point to a gap in Malaysian research for a more integrated and comparative approach.
Assalamualaikum and hi everyone. My name is Hansa. Our group's topic today is Challenges in Implementing Duty of Care in Healthcare. Duty of care is a legal obligation that requires doctors, nurses, and hospitals to provide reasonable and safe care once they accept a patient. Once a healthcare provider takes responsibility for a patient, they must act with the level of care and skill expected from a competent professional in the same situation. Medical negligence happens when a provider falls below that standard of care and the patient suffers foreseeable harm because of it. It is important to note that delivering this duty of care consistently is challenging due to legal and regulatory pressure, resource shortages, and technology risks. I will now explain the challenges in implementing duty of care in healthcare. First, legal and regulatory pressures. Providers must follow rules on documentation, confidentiality, and informed consent. Strict requirements can increase paperwork and reduce time for patient communication. Fear of being sued may also lead to defensive medicine, such as extra tests or referrals, which can raise costs, delay decisions, and sometimes expose patients to unnecessary procedures. Next, resource constraints. This means the healthcare system is trying to deliver care with limited staff, funding, and facilities. When there are not enough nurses, doctors, beds, or equipment, care becomes rushed and delayed. It gets harder to monitor patients properly, follow up test results, communicate clearly, and do safe handovers. From a tort law perspective, negligence is not only about a careless person. System pressure can cause important steps to be missed, and those missed steps can lead to preventable harm. Technology improves care, but it also creates new risks. Cybersecurity breaches and data leaks can affect confidentiality and patient trust, while system downtime can delay access to records, test results, and medication orders. And finally, AI adds a new layer to clinical decision-making. Even if AI supports diagnosis or treatment, clinicians still remain responsible, and patients should be informed if AI is used as part of treatment decision. Overall, these challenges show that duty of care is not only affected by individual actions, but also by legal pressure, system capacity, and technology, which shape how safely care can be delivered.
Hi, I'm Adrana Khalisa. Now I'll explain how Malaysians court implement the duty of care in healthcare. This duty is shaped by three key challenges: legal and regulatory pressures, resource constraints, and technological limitations. The following cases show how the judiciary addresses the challenge while balancing patient protection with medical realities. In Fufiona and Dr. Su Fok Moon, the federal court considered whether doctors have a duty to disclose material risks to competent patients. The court rejected the Bolam test for informed consent and adopted the Rogers and Whittaker approach, holding that disclosure is governed by legal standards of reasonableness. Because the risk of paralysis was real and foreseeable, the failure to disclose it meant the patient's consent was not informed. So this case shows that Malaysian courts strongly protect patient autonomy and impose strict disclosure obligations on medical practitioners. Next, in Xiao Qingyi and Columbia Asia Setia Berhad, the issue was whether a hospital could avoid liability by relying on the independent contractor status of doctors. The federal court held that hospitals owe a non-delegable duty of care, especially in emergency situations. So by applying statutory duties under the Private Healthcare Facilities and Services Act 1998, the court made it clear that resource constraints do not excuse lapses in care. So this case confirms that hospitals bear ultimate responsibility for patient safety. Furthermore, in Dr. Chin Yun Hiap and Ng Kyu Hoon, the Court of Appeal examined negligence in neonatal care. The court held that medical conduct must be assessed based on the technology and medical knowledge available at the material time and not with hindsight. As no effective monitoring or preventive measures existed then, the defendants were found to have acted in accordance with accepted medical practice. So this case shows that technological limitations define the boundaries of duty of care. So in conclusion, Malaysian courts adapt a balanced and context-sensitive approach to medical negligence. While patient protection remains central, the duty of care is shaped by legal standards, institutional responsibility, and technological limits.
Now we shall move to the comparative analysis between Malaysia and Switzerland. Before that, let me introduce myself. I'm Aisha Nurjana. Now let's compare the legal foundations of both Malaysia and Switzerland first. Based on our findings, in Malaysia, duty of care is largely shaped by court's decisions such as Fu Fiona's case, where the federal court strengthened informed consent obligations. This basically means that legal protection developed reactively after harm occurs. In contrast, Switzerland operates under a civil law system where duties are codified in statutes like the Swiss Code of Obligations. As a result, healthcare providers have clearer, predefined legal responsibilities. It is highly notable that in Malaysia, the burden of proof remains on the patient to establish breach and causation, which can be difficult in complex medical cases. While Switzerland takes a more patient-centered approach, failure to properly document consent or procedures can shift the burden of proof to the healthcare institution, making compensation more accessible. Moving forward, the difference becomes clearer when we examine systematic negligence. Malaysia traditionally focuses on individual liability, although recent cases like Xiao Qing Yi shows a judicial shift towards non-delegable duty for hospitals. Switzerland goes further by recognizing institutional and state liability, especially where harm arises from system failure rather than individual fault. Regarding to financing as a duty of care, Switzerland's mandatory insurance system under LAMAL transforms healthcare into a legal duty shared by society. Insurers cannot reject high-risk patients, ensuring universal protection. Malaysia provides affordable public healthcare, but without mandatory insurance, the legal duty of care is less structurally embedded. Moving forward, technology highlights the biggest gap. Malaysia's PDPA provides only general data protection, leaving healthcare-specific digital risks under-regulated. However, Switzerland's revised data protection law treats cybersecurity failures and AI risks as legally foreseeable, making digital safety part of the duty of care. The comparative analysis has brought us to a conclusion. Malaysia's challenge is not weak law, but fragmented implementation. Switzerland shows that when duty of care is built into institutions, financing, and technology, governance, patients' protection becomes proactive rather than reactive. For Malaysia, strengthening institutional accountability is key to closing this gap.
Hello everyone, my groupmates have already talked about the duty of care and the problems in medical negligence cases in Malaysia, and my name is Wu Xinyi. Now I will move on to the reform part. This section looks at policy reform in Malaysia and how they can improve the duty of care in healthcare. Instead of just point out problems, we focus on practical solutions at the legal, institutional, and system level. The aim is to protect patient safety while also supporting healthcare professionals. Firstly, doctors often face unclear legal rules and afraid of being sued. This can affect decision-making and lead to defensive medicine. One way to address this by setting clear national clinical practice guidelines, especially for high-risk cases. This allows doctors to be assessed based on reasonable professional practice. In addition, informed consent can be strengthened through clear explanation and better communication with patient. And mediation should also be encouraged, so disputes can be solved faster and with less conflict. Besides legal rules, resources are also important. Resources shortage places strong pressure on healthcare providers. They increase delays, fatigue, and the risk of medical errors. To improve this, healthcare funding should be increased to upgrade facilities and replace old equipment. It also can be used to hire more healthcare staff and improve working conditions, so fatigue and mistakes can be reduced. Also, police support for rural clinics can further reduce the urban-rural healthcare gap. Move to the next slide. Healthcare today relies heavily on technology. When systems fail or staff are not properly trained, patient safety may be affected. Hospitals therefore need to protect patient data and strengthen digital safety. Regular system checks and clear backup plans can reduce the impact of system failure. Proper training for doctor and nurse is also important when new systems such as electronic health records are introduced. In conclusion, this presentation shows that problems with the duty of care are not caused by individual doctor law. Legal pressure, limited resources, and technology all affect medical practice. Malaysia courts aim to protect patients while recognizing the limits faced by healthcare providers. Therefore, improving the duty of care requires a system-based approach. With clear law, better resources, proper use of technology, and policy reform, Malaysia can improve patient safety while supporting medical professionals. That's all from us. Thank you for your listening.